Hello and welcome to this session on data privacy concerns in relation to vaccines and vaccination policies in the workplace. As you know, I'm Catherine Weaver. I'm an employment partner at Lewis Silkin in Hong Kong, and I also head up the Hong Kong office. In this session, I intend to provide you with a brief overview of the current situation in relation to vaccinations in Hong Kong, before exploring what employers need to consider from a data privacy perspective if they want to collect employees' vaccination data. I'll be discussing the law and also practical steps, together with sanctions for when the data privacy laws are breached. And while I'm going to be talking to you about Hong Kong law specifically, some of the principles will be the same in relation to data privacy considerations as they are in other jurisdictions. So Hong Kong's vaccination programme launched on the 26th of February 2021. And although vaccines were free of charge and available to a wide range of the population, the uptake of the vaccines was actually very low. And as there were very few cases of COVID-19 in Hong Kong at the time, and the city hadn't really experienced a lockdown similar to other countries, people felt as though the vaccine wasn't vital and they adopted to do the wait and see approach. That was what was happening at the beginning, but currently Hong Kong's vaccination rate has now increased, with around 49% of the population having now received their first dose. And that increase in the vaccination rate has no doubt been boosted by a number of incentives and lucky draws adopted by private companies in recent months. There's things such as shopping vouchers and discounted hotels and even a lucky draw of a multi-million-dollar flat. The Hong Kong government has also introduced measures to incentivise citizens to get vaccinated, such as reducing compulsory hotel-based quarantine periods for those who are vaccinated. And then earlier this week, it announced that unvaccinated government employees would need to start paying for regular COVID-19 tests, so once every 2 weeks if they refuse to get vaccinated. Employers in Hong Kong have tended to adopt more of a carrot rather than a stick approach so far when it comes to vaccinations. They've been offering additional holidays and time off and cash bonuses for those who are vaccinated, rather than seeking to actively penalise those who are not. But we're now starting to hear from employers who are keen for their workplace to return to normal by removing social distancing rules and masks, etc. And they therefore want to look into whether they can actually ask their workforce for vaccination status data in order to make those decisions. The question therefore arises as to whether it's legally acceptable to ask employees for personal data regarding their vaccination status, and if so, how employers should go about doing it. But before we answer that, it's probably best if we just briefly cover some of the basic definitions and principles of data privacy law in Hong Kong. So Hong Kong's main data protection legislation is the Personal Data Privacy Ordinance, and that's been around since 1996. That's when it came into force, and that makes it one of Asia's longest standing data protection laws. The ordinance is based on 6 data protection principles, which set out how data users should collect, handle, and use personal data. And when we talk about personal data in the context of the PDPO, we mean information which relates to a living individual and can be used to identify that individual. It must also exist in a form which access to or processing of is practicable. Other useful definitions to know are data subject, which is the person who is the subject of the personal data, and data user, which is the entity that controls the collection, holding, processing, or use of personal data. And that entity can do this alone or jointly with other entities. The data protection principles set out that personal data should be collected on an informed basis and in a fair manner, with consideration given to minimising the amount of personal data collected. And when processing personal data, that should be done securely, and the data should only be retained for as long as necessary to achieve the purposes for which it was collected. Use of personal data should be limited to or related to the original collection purpose, and data subjects should be given the right to access and make corrections to their personal data. The way that companies or data users in Hong Kong tend to deal with the collection of personal data practically is through issuing a personal information collection statement, or a PICS as it's more commonly known. In other jurisdictions, the same outcome may be achieved by issuing a privacy notice or having a data privacy policy in place. Now, PICs are usually provided to candidates when they're asked for their personal data during a recruitment process, and also to new joiners when they provide their personal data as part of the onboarding process. They're often drafted quite broadly to allow employers to collect all the information they may possibly need from employees for all possible business purposes. But there's no limit on how many PICs an employer can issue. So employers may decide to issue new PICs throughout an employee's employment if they deem it necessary or prudent to do so. The purpose of the PICs is largely to comply with the notification requirements under the PDPO. Therefore, a PICs should include the following information that's set out on the slide. It should state the purposes for which personal data will be used, whether it's obligatory or voluntary for individuals to supply the requested personal data, and then the consequences of not supplying the personal data if it's mandatory to do so. The classes of persons to whom the personal data shall be transferred or disclosed. And then when dealing with direct marketing, the PIC should also provide information about how the personal data will be used for direct marketing purposes. And finally, the PIC should also highlight the data subject's rights of access to and correction of personal data, together with the contact details of the data protection officer who will handle such access and requests for correction. So, how do vaccination policies fit into all of this? Well, first we have to consider whether vaccination status constitutes personal data under the PDPO. And given that vaccination history and the name of the employee and/or their Hong Kong ID number will usually be in the same place, this will constitute information which relates to a living individual and which can be used to identify that individual. And also, a vaccination record is usually in a form to which access is practicable. So, information regarding an employee's vaccination history will likely constitute personal data under the PDPO unless that information is entirely anonymised. So second, we need to consider how we collect that personal data from employees in a way that is compliant with the PDPO. And when thinking about this, employers should have in mind the following things. What data do they want to collect? Why do they want to collect it? Who, if anyone, do they want to share that data with? How are they going to ask for that data? And how will that data then be stored and secured? I'm going to take each one of those points in turn and consider them in a little more detail, starting with what data is to be collected. Now, remember, it's important to note that the PDPO emphasises minimising the amount of personal data that data users collect, and that data users should only collect information that is necessary and not excessive for the designated purpose. So where an employer simply asks for a yes/no answer as to whether an employee has been vaccinated, that's unlikely to be considered excessive. But if the employer also asks for the date of the first vaccination, the date of the second vaccination, the type of vaccine, or the reason for not being vaccinated, then there is a risk this may be considered excessive if the employer is unable to explain why it's necessary for it to collect this personal data. Employers are also required to specify whether it's voluntary or mandatory to provide the requested personal data, and if mandatory, the consequences of the employee not doing so. If the provision of the personal data is voluntary, employers should also consider how they're going to treat those who opt out of providing any data. Should they be treated for the purpose of the employer's plans as though they were unvaccinated? On this slide, we've got a screenshot effectively of the information that you may get in a vaccination record. And employers often ask whether it's okay to obtain proof of vaccination status from employees. So this kind of screenshot or test results. And again, the question will be whether it's necessary to have a copy of the vaccination record in order to achieve the data user's stated purpose. A vaccination record can include personal data that the employer may not need in order to, for example, decide on their return to work strategy. It can show the date of the first dose, the type of the vaccine that was administered, and that is unlikely to affect many businesses' return to work policies. So question whether you need that information. So employers may prefer instead to collect personal data from employees in a form or using an app, rather than asking them to provide copies of their vaccination records. An employer must also consider what the purpose of collection of the personal data is and notify the employee of this in advance. With regard to vaccination status, the purpose is usually going to be for employers to be able to carry out a risk-based assessment of when to return to working in the office as normal, and to be able to reduce social distancing measures at work, with the overall purpose being to ensure the health and safety of their workforce in light of COVID-19. Other purposes could include monitoring vaccination numbers in the workforce for internal or government reporting purposes. And if the employers have incentive schemes in place for those who are vaccinated, they're going to need that information about vaccination status in order to be able to allocate the incentives. In particular industries that are subject to government legislation mandating staff to be vaccinated, employers will also therefore have a clear purpose for collecting that personal data. Employers have to consider who, if anyone, they're likely to disclose this personal data to, and then notify the employees of this in advance. With regard to vaccination status, it's unlikely that the employer will want to disclose this personal data to a large number of third parties, but an employer may need to notify payroll if bonuses, benefits are to be allocated based on vaccination status. They may want to share information with third parties who are providing those benefits to vaccinated employees. They might want to share that data with group companies for the purpose of monitoring and deciding on group policies, and or they might share data with their advisors when considering and seeking advice on risk assessments. When deciding how to collect vaccination status data, employers should first consider whether their existing personal information collection statement, their PICS, covers this situation already, and depending on how broadly it's drafted, it might do. But if the PICS doesn't cover this situation, then the employer should then draft a new PICS to deal with the collection of vaccination status personal data and provide this to the employees prior to them giving their personal data. It should also be noted that if the employer later down the line wishes to use that vaccination status data they've collected from employees for a different purpose that's not notified to the employee in advance of the collection, they're going to need to seek express consent from employees to use that data for this new purpose. How should personal data be stored and secured? Well, all personal data should be processed by data users in a secure manner and should only be retained for as long as necessary to achieve the designated purposes. So employers are going to need to consider where it's going to put this data, who's going to have access to it, how they're going to ensure no leakage or unauthorized access of it. And they're also going to need to have a retention policy in place so they can ensure they dispose of the personal data once it's no longer necessary to retain it. On this next slide, I have set out a reminder of the steps to go through when considering whether to bring in a vaccination policy. And we've talked about all these points, so this is really intended to be a bit of a checklist. And the main steps to note are: consider whether the collection of data in relation to vaccination status is actually necessary to achieve the company's purpose. And if it is, then ensure that the amount of personal data collected is minimised and collected for a clear purpose. Check whether you have the right to ask employees for this personal data. For example, has the employee also received a personal information collection statement that's going to cover obtaining personal data relating to vaccination status? If that PICS is already in place, then you may be able to just proceed to request that data in accordance with the PDPO without any further PICS needing to be drafted. But if you don't already have that PICS in place that covers this particular scenario, then you're going to need to draft a PICS to cover it and ensure you provide that to the employees in advance. Remember that if you want to use the collected data for another purpose later on, you're going to need consent from the data subject to do that. And once the vaccination status data has been collected, make sure you follow the PDPO in the terms of the way in which you store and secure that data. So what happens if an employee is disgruntled by the way in which his or her vaccination status data is dealt with? Well, if they are, they have the right to lodge a complaint against the data user with the Office of Privacy Commissioner for Personal Data. And the Commissioner then has to investigate that complaint unless they consider it to be without merit and not worth pursuing. The Commissioner may then publish a report and recommendations regarding its investigation, and they may also issue an enforcement notice directing steps to be taken by the data user to remedy or to prevent the potential data breach. It should be noted that it's not actually an offence to breach one of the 6 data protection principles in the PDPO, but there are other provisions in the PDPO that it is an offence to breach. And also, if you fail to follow the terms of the enforcement notice issued to you, that would amount to an offence. And the maximum fine for that is 50,000 Hong Kong dollars, plus a potential 2 years imprisonment, plus a daily penalty of 1,000 Hong Kong dollars. And in addition to that process, a data subject could also bring a civil suit against the data user for breach of the PDPO and claim damages. And finally, the Commissioner does also have the power to act of its own volition to proactively inspect data users' data systems and make recommendations. Well, that then concludes this brief canter through data privacy concerns for employers in relation to vaccination policies. And if you have any questions regarding this, please do feel free to contact me on the details on the screen now.